So we will kind of just do a high-level overview, point and look at some of the things that are happening, and feel free to contact me if you have any other general questions about this. I am not your lawyer unless you are work for Shutterstock. So we can go on to the next slide. There are a number of different developments happening in privacy law. The biggest ones right now are that, following the adoption of the GDPR in the EU, there have been a number of different comprehensive privacy laws and consumer privacy laws adopted in places like Brazil, California, Colorado, Virginia, Connecticut, Quebec, and more of those are happening all the time. Other things to be aware of when considering what your requirements are dealing with personal information or personal data of anyone who you work with are email marketing laws, biometric privacy laws, and whether or not you're transferring data internationally. So we can move on to the next slide. The EU GDPR, the General Data Protection Regulation, is right now the global standard for privacy laws. It treats data protection as a fundamental human right. So it applies to everyone who processes, meaning anyone who does anything with personal data of any EU individual or does that within the EU. So it applies to US companies who have EU customers or agents who represent EU photographers. It applies to any business that does business in the EU, and it relates to any personal data. So that's any information that relates to an identified or identifiable person. There are certain types of sensitive personal data, such as ethnic or racial information, health data, that require a higher level of care, but any type of personal data requires care. And so that means being fair, transparent, and accurate in how you handle the data, ensure that it's being secured and kept confidential, and that you respect the individual rights of data subjects. So people whose data is being processed have the right to access copies of their data. They have the right to delete information when it's no longer needed. They have the right to object to types of processing and not be subjected to decision-making based purely on automated artificial intelligence. They also restrict the transfer of data from the EU to countries that do not have comparable levels of protection. So if you can go to the next slide. And so what we're seeing in the 4 years since GDPR has come into effect is more states, countries adopting new laws that are comprehensive like GDPR. So you may have heard over the last couple of years about the California Consumer Privacy Act, the CCPA, which is being replaced on January 1st by the CPRA, the California Privacy Rights Act, which is a little more protective of consumer privacy for California consumers, and it harmonizes the individual rights a little more with what's available under GDPR, but it's not universally applicable. So it only applies to businesses that collect personal information from California residents that meet any of a certain number of one of these three thresholds. So it either is a business that does more than $25 million in gross annual revenue, buys, sells, or shares personal information of 100,000 or more California residents or California households, or its business is majority, at least 50% of their annual revenue comes from selling or sharing California personal information. Let's go on to the next slide. And so what's new with CPRA versus what's in effect currently in California is that consumers are required to have the opportunity, the right to opt out from the sale of their personal information. they have a right of access to certain personal information. The CCPA limited it to only information that was collected or processed over the last 12 months. CPRA aligns more closely to the GDPR's view, where it's any information that a business holds about a consumer. It also adds a right to correct, requires certain additional disclosures in online privacy policies, and creates a concept of sensitive personal information, which includes information about race and ethnicity and precise geolocation, which may be very relevant in things like model information. And it also, if you employ people in California, it also now applies to employee personal information as well, if your business is otherwise subject to CPRA. We can move on to the next slide. And California is the first, but not the only US state to have a new consumer privacy law coming into effect. Virginia, Colorado, Connecticut, and Utah all have laws coming into effect during 2023. All of them are similar to California in that they are applying to businesses processing consumer information. The enforcement of these will phase in over the year, and they're also limited to certain types of businesses that do business within the states. But what we will expect to see over the next year is the expansion of even more and more states adopting privacy laws. Washington and New York in particular have had laws go into the legislatures for the last couple of years that have come close to, but not quite passing. And I would expect those to attempt again. There's an attempt to enact a federal privacy law that made significant progress this year. And it's not in the slide, but also the FTC is taking a more aggressive role in pursuing companies that suffer data breaches or fail to otherwise protect the information of the personal information or personal data that they may fail to be transparent about their collection of, or fail to secure and suffer a breach. Move on to the next slide. Another key concern is the use of cookies and trackings on websites and mobile applications. The EU GDPR and e-privacy directive combine to require that users are provided with the opportunity to provide meaningful and informed opt-in consent before the site or app places any cookies or trackers on a device, unless those are ones that are strictly necessary for the essential operation of the site or app, which include things like load balancing and shopping carts, not typically things like tracking and many of the advertising purposes that cookies are used for. This is something that's attracted a lot of attention from European regulators. The French Data Protection Authority, CNIL, fined Google 150 million euros and Facebook 60 million euros last year for not making cookies, opting out of cookies easy as opting into them. California requires, as part of the CCPA and CPRA, to opt out of the sale or sharing of personal information. And that includes information collected to do online advertising. So if you operate a website and you use tracker cookie technology to identify shoppers and then follow them around so that ads for your services will appear in their other web viewing, that may be covered under CCPA, CPRA requirements to opt out. Okay, let's move on. Email marketing. Also, if you're doing it in the EU and Canada, you must have affirmative or informed consent, which cannot be in the form of a pre-checked box. Next slide. One thing that's of increasing note are biometric privacy laws. There are 3 states in particular, Illinois, Texas, and Washington, that have laws that protect biometric information, which can include scans of facial geometry. Scans of facial geometry are used in recognition of individuals. So this has been an area of intense litigation in Illinois, where the Illinois Biometric Information Privacy Act, BIPA, was the basis for some litigation against Facebook in particular over their use of facial recognition technology to create profiles from photographs. Next slide.
Yeah, sorry, I just want to jump into it. And then
Texas
is starting to get active now too. So the AG in Texas, I think last week, filed a suit against Google, I believe. Is that right?
Yeah, that's right. And the difference between Illinois and Texas and Washington is that Illinois has a private right of action. So there's the chance for class actions against using facial geometry scans from any person in Illinois, whereas in Texas and Washington, those are done through consumer protection laws or the Attorney General's office, who would have to pursue that action.
Right. Thanks.
So what can you do to comply with this huge amount of laws? Build a data privacy program, understand what data you have, who you share it with, designate someone who's responsible for privacy in the organization, have an information security program. Security and privacy are not necessarily the same thing, but they overlap quite a bit, and you can't have good privacy without having information security. And have a way to handle cookie, email, and other preference and consent management, as well as responding to user requests to access, delete, correct, update their information that you have. And always be ready for change. So that's also the theme of the next slide. Compliance is a journey. This is such a fast-moving space that the laws are changing. So much of complying with privacy law is also providing good customer service, being able to identify what information you have, and respect individual choices about how it's used.
Great. Thanks, Andrew.